Does a child have a duty to care for an aging parent? The court in Billingslea v. State looked beyond an ethical question and determined whether a person can be legally charged with failing to provide care if there isn't a statutory duty to act. In 1964, Hazel Billingslea moved in with her adult son, Ray. In 1984, when Hazel was 94 years old, Hazel's overall health worsened, and she became bedbound. Before Hazel became bedbound, Hazel's granddaughter, Virginia, who was Ray's niece, would often visit Hazel at Ray's house. However, after Hazel became bedbound, Ray prevented Virginia from seeing Hazel. Virginia called numerous times to check on Hazel, but Ray forcefully told Virginia to mind her own business, or Ray would kill her. Virginia contacted her mother, Ray's sister, and informed her mother of the situation. Virginia's mother contacted social services for a welfare check. When Adult Protective Services and the police entered Ray's home, they found Hazel moaning in pain in bed. Hazel was sitting in her own excrement, and she had numerous open bedsores that were infested with maggots. After Hazel was transported to a hospital, a doctor confirmed that Hazel's condition was the result of severe neglect over the previous months. Hazel died 11 days after she was brought to the hospital. Ray was charged with injury to an elderly individual under Texas law. A jury convicted Ray and sentenced him to 99 years in prison. Ray appealed. The Court of Appeals reversed Ray's conviction. The Court of Appeals held that the statute only stated that an omission or failure to act is a crime. But the statute didn't clearly explain what inaction is considered an omission, or what parties are bound by the corresponding duty to act under the statute. The state petitioned the Texas Court of Criminal Appeals for discretionary review of Ray's acquittal.